The Right to Die and Physician-Assisted Suicide by Olivia Sanders, Yvonne Moore, Adina Schulter-Manner, Logan Crum, Maddie Hine, Adam Parsons, and Mike Lang. According to the Canadian Medical Association, euthanasia is defined as knowingly and intentionally performing an act that is explicitly intended to end another person's life, and the act is undertaken with empathy and compassion and without personal gain. In addition, there are three categories of euthanasia: voluntary, where the patient is competent and has asked for their life to be ended; involuntary, where the patient has not expressed preference regarding aid in dying or is unable to make informed decisions; and passive euthanasia, where the patient dies because physicians either do not do something necessary to keep the patient alive or physicians stop doing something that keeps the patient alive. Assistance in suicide is knowingly and intentionally providing a person with the knowledge or means, or both, required to commit suicide, including counseling about lethal doses of drugs, prescribing such lethal doses, or supplying the drugs. Physician-assisted suicide is currently legal in 6 states: California, Colorado, Oregon, Vermont, Washington, and Montana, in addition to Washington, D.C. All states where it is legal was passed by legislation, with the exception of Montana, which was passed by court ruling in the case Baxter v. Montana. The first to pass legislation was Oregon in 1994, followed by Washington in 2008, Montana in 2009, Vermont in 2013, California in 2015, and Colorado in 2016. All of these laws were passed in very slim votes, usually by around a 51% majority. In Oregon, as of January 2016, there have been 1,545 people who were given prescriptions, and 991 people have died from those legally prescribed drugs. In Washington, since 2009, 725 people have been given prescriptions, and there have been 712 reported deaths. In Vermont, between 2013 and 2016, 24 physician forums have been completed for physician-assisted deaths, according to CNN. Clearly, these legislations have been effective, and the majority of requests to physicians have been carried out.
Oregon was the first U.S. state to permit terminally ill patients to determine the time of their own death. In 1994, the Death with Dignity Act was established and was fully approved on November 8, 1994. There was originally a ban on this act, however, the ban was lifted on October 27, 1997. Clarifying what the Death with Dignity Act entails is necessary when understanding physician-assisted suicide. This act allows terminally ill patients to obtain and use lethal medications from their physicians. Under the act, ending one's life is not considered suicide, mercy killing, or homicide. The act prohibits euthanasia, where a physician or other person directly administers a medication to end another's life. In all of the states where physician-assisted suicide is legal, there might be a different name for the act allowing physician-assisted suicide. However, all of them have similar requirements and restrictions. 2 court cases are important to mention regarding physician-assisted suicide. The first case is Washington v. Glucksberg. This case involved the state of Washington and Dr. Harold Glucksberg. At the time of the case, Washington had a ban on physician-assisted suicide. Washington deemed assisted suicide as criminal, and Glucksberg fought that Washington ban and deemed it unconstitutional. Glucksberg felt as though assisted suicide was protected by the Due Process Clause of the 14th Amendment. This case went back and forth between the U.S. District Court, the U.S. Court of Appeals, and the Supreme Court of the U.S. However, the final decision was that the ban was rational and preserved human life. It was also agreed that this ban protected mentally ill and disabled patients from malpractice. The court felt that allowing physician-assisted suicide would lead to abuse of it by people that aren't terminally ill, yet still want to end their life. In 2008, Washington voted in favor of the Death with Dignity Act, with a 58% voters in favor of this act. The second case worth mentioning on this topic is Vacco v. Quill. Dr. Timothy Quill challenged the assisted suicide ban in New York and claimed it violated people's 14th Amendment rights, similar to the claims made by Dr. Glucksberg. The Supreme Court of the U.S. decided that New York's ban doesn't violate the equal protection rights of terminally ill patients. In New York, there are at least 2 versions of legislation that have been introduced to give terminal patients the ability to end their lives sooner than their diseases would.
There are many pros to physician-assisted suicide that benefit recipients in many ways. The court's recent decision describes that a terminally ill person who is mentally competent has a protected liberty interest in choosing to end intolerable suffering by bringing about his or her own death. It is not fair for a patient to be forced to suffer when he or she knows that they are terminally ill and are near death. Many believe that it should be considered a crime to make the patient suffer. If an individual is terminally ill and wishes to die, we should respect this wish because we could be saving money for patients who are not wanting to die and who could be cured. Because of the way that our healthcare system is financed, we could be wasting a lot of money. Drugs for assisted suicide cost $35 to $45, which is far less expensive than medical care. Death happens to everyone at some point, but it should not be the government's decision of when. If a patient is terminally ill, this hard decision should fall in the hands of the patient and their family. Evidence shows that physician-assisted suicide is an easier emotional option rather than watching a loved one go through palliative care. A fear of many is that if a patient is denied physician-assisted suicide, then they could go as far as to end their own life in a dangerous and harmful way because they want to die. These are the reasons some people believe that physician-assisted death should not be legal. To start, when most physicians get through medical school, they take a Hippocratic oath, which regards the proper behaviors and ethics doctors must practice. The part of the oath violated by physician-assisted death is the Latin phrase primum non cursare, which means first do not harm, which means the doctors can only heal, not harm their patient. Secondly, many religions strictly prohibit any form of suicide and consider it an act against God. Non-religious people also believe it is against common moral and ethical codes. Next, people who oppose the right to die suggest that allowing doctors to kill people is a slippery slope that could lead to a dangerous future with legalized murder for certain situations. Also, unethical doctors could begin to start euthanizing people for the wrong reasons, even start encouraging it as an option to their patients. Additionally, when insurance and inheritance get involved, people could begin to make these life-ending decisions for monetary gains. And when dollar figures are attached to human life, controversy always ensues. Lastly, opponents contest that many of the people who choose this form of dying are elderly individuals, and that these individuals may not have their full mental capacity and are in no form to be making such serious and permanent decisions.
Seeing previous facts and statistics are important when discussing physician-assisted suicide. However, personal stories are what raise debates and conversations between people. 3 years ago, a 29-year-old woman named Brittany Maynard publicly decided to end her life. After being diagnosed with an aggressive brain tumor and finding out there were no treatments available, Brittany and her husband of 1 year moved to Oregon to access the Death with Dignity Act, and Brittany ended her life on November 1st, 2014. One quote from Brittany that particularly stood out was when she said, "I am not suicidal. I do not want to die, but I am dying, and I want to die on my own terms." This raised a lot of debate on this topic and made people aware that physician-assisted suicide wasn't a result of depression, cyberbullying, or the desire to end your life. Physician-assisted suicide is available to terminally ill people who are already going to die. They see death as inevitable in the near future and prefer to pass away before their condition makes their last months unnecessarily painful. Brittany wanted her story to be very public so that it raised discussions about this topic, and she's hoping that more states open up to the idea of allowing people to die with dignity. This video from CBS highlights on it further.
Maynard said she's choosing quality. After her diagnosis, she moved to Portland, Oregon, one of 5 states where it's legal for doctors to help terminally ill patients take their own lives. She decided to partner with the leading organization that's pushing other states to change their laws. Her candor about death has revived the national debate over physician aid in dying. In a recent poll by the New England Journal of Medicine, 67% of healthcare providers said they oppose the practice, as does the American Medical Association. Many fear it could be abused in cases involving the elderly and disabled.
In Brittany Maynard's case, she highlighted multiple times that having the medicine to end her life gave her much relief, even before she took it. This same relief was felt by Ethan Remmel, a 41-year-old man who chose assisted suicide and died on June 13, 2011, after being diagnosed with terminal colon cancer. Having that sense of control was important for Remmel and made his last day happen the way he chose. Wang, his wife, said Remmel didn't regard taking the lethal drugs as suicide. We obviously didn't want him to die, but he was dying anyway. In both Brittany Maynard's case and in this instance, neither party considered physician-assisted suicide as actual suicide. Ethan used Washington's Death with Dignity Act and hopes that his story and his blog titled Living While Dying will continue to spark debates on this issue, and he hopes that one day this option will be available for anyone and everyone who wants it.
With regards to the future of the Right to Die movement, here is a map portraying the current standing of each state with laws concerning right to die. Just this January, House Bill 1561 was introduced by Representative Matt Pierce. Indiana is one of the many states considering right to die legislation. In closing, during this presentation, we have discussed the locations in which the individual right to die is protected, statistics on the topic, the Death with Dignity Act, requirements concerning who qualifies as a right to die candidate, the very important case of Washington v. Glucksberg, the pros and cons, key famous instances such as those of Brittany Maynard and Ethan Remmel, and finally, the future of the right to die movement.